Okay, so I think I'm going to introduce her now. That's good with everyone because enough people had settled in. So, Bruna Frata is our founder and principal attorney. She's well versed in business immigration and has experience in the U.S. immigration with large multinational corporations and regional companies in the oil and gas, pharmaceutical, technology, and engineering industries. Her experience encompasses assessing clients' U.S. immigration needs, developing and facilitating short and long-term immigration strategies. Attorney Bruna Frata also assists high-skills individuals, executive and managers obtain self-sponsored visas and green cards such as EB-1 Extraordinary Ability, EB-1 Outstanding Professional and Researchers, EB-2 Labor Certification, EB-2 National Interest Waiver, and EB-3 Labor Certification in Schedule A. She worked for leading immigration law firms such as Barry Appelman and Leiden LLP, and DeMont, McChesney, Curtright, and Armendariz LLP before opening her own practice. She also worked as an immigration attorney for leading relocation company, Santa Fe Relocation. Bruna Frata has a team of paralegals and of counsels delivering outstanding customer service to our clients. Attorney Bruna Frata also serves as a general counsel for Consulate General of Brazil in Houston and Tramontina, USA, Inc. So now you can hear from Attorney Bruna herself since she's here on call.
Thanks, Leah, for the great presentation. I feel flattered hearing all those amazing accomplishments from my daughter. So if you were guessing who Leah Frota is, she's my own daughter. That's why we look so alike. Great job, Leah. So thanks everybody for joining. I understand that your time is very precious and we want to make sure that we leverage with the best information that we can share with you. So today I don't wanna waste your time going through the very basic information that you can read online about marriage-based green cards. I want to educate you and also share some tips and what's going on nowadays under the Trump administration and what you can expect as you go through your marriage-based application green card. So if this presentation I can also share with you all, if you are interested, just make sure that you email us and request a copy of the presentation. But we also have the presentation recorded and it will be available in our YouTube channel. So a marriage-based green card allows U.S. citizen spouses and the spouses of green card holders to come to the U.S. to live with that U.S. citizen or green card holder in the U.S. And it's basically a way for those individuals to get, of course, the right to live and to work in the U.S. and then eventually also apply for their own citizenship through a naturalization process. There are several benefits of going through this type of green card when compared to other types of green cards that I will discuss during this presentation. But one of the most important things is to understand is that there are two main ways of you getting this type of green card. Either if you are residing in the US, you can go through the adjustment of status application process, and then if you are outside the United States, you go through a the consular process instead. The benefit of going through the green card application in the US is that you're going to have the right to work while you wait for the adjudication of your green card, whereas if you go through the process outside the US, you're not going to have this benefit, but you also have other benefits when compared to the adjustment of status application. So in order to be eligible for this type of green card, one, you need to be married to a US citizen or a green card holder. It doesn't matter how long your spouse has been a green card holder. It doesn't matter whether your green card already has a permanent resident green card or if it's just a conditional permanent green card. And also, it doesn't matter whether your US citizen spouse gained citizenship by birth or by naturalization or through their parents. As long as they have proof of their status, they can apply for your green card. And then, of course, you need to be a foreign individual that married this petitioner, who is a US citizen or a green card holder. Of course, you have to show that this relationship it's bona fide, meaning that this person did not marry you just to give you a green card, or you did not marry that person with the intent to get a green card. The green card is just a consequence, it's just a result of your relationship. And because you are together as a couple, you are coming to the US to reside with your spouse in the US. Again, if you marry someone, right, you need to look at the laws of the place that you got married to make sure that the United States recognize that marriage for immigration purposes. And I can give you some examples later on when marriages, especially common law marriages, are not accepted by the US government. But you need to have a marital relationship with that US citizen spouse or green card holder. A lot of the times, of course, as you go through the process before you even apply for your green card, you need to collect as much as evidence as possible that you live or that you either live together, right, which is going to be the most successful cases, but you can also apply for that green card if you don't live together, especially if you are going through the consular process instead, where you show that although you are not in that same, just 1 second, everyone. See it?
Yep.
Awesome.
Yes.
I apologize, everybody. But this is the first slide. This is the second, the third, and then that's where I stopped. Okay. Alrighty. So continuing. Of course, as I said, the US government will have to recognize your marriage depending on the location that you got married, of course, in order for you to receive this benefit. Of course, here in the US, you cannot be married to more than one person at the same time. Therefore, if you have been married before, you need proof that those marriages were terminated before you married your US citizen spouse or green card holder. If you have any criminal or immigration violation, please make sure that you share that information with your attorney before you move forward with your green card application, because depending on the complexity of that violation or the seriousness that violation, you can be ineligible to receive a green card or even have to go through a process called waiver of inadmissibility before you are entitled or eligible to receive your green card. So that's how the process looks like if you are inside the United States and you qualify for the filing of an adjustment of status. So first of all, in order to qualify for the adjustment of status application, you need to be physically present in the US, and you should have entered the US with admission and inspection and or paroled. Meaning you need to have a visa, you need to have an ESTA, you need to be paroled into the US in order to file your adjustment of status application. If you enter the US without inspection, meaning if you enter the US through the border, for example, using a coyote, for example, you're not going to be able to adjust your status unless you qualify under Section 245I, meaning back in 2001, before 2001, someone or a company filed a Form I-130, I-140, or a labor certification on your behalf. Then in that case, you can file for your adjustment of status application and pay a penalty of $1,000 to be able to adjust your status in the US. So that's the first requirement. Then secondly, you need to be married to that US citizen spouse or LPR holder. That petitioner, which is the US citizen or the green card holder, will file a Form I-130 with immigration. The agency is called USCIS. It stands for United States Citizenship and Immigration Services. In that form, the US citizen or the green card holder will show that they have the qualification to be the sponsor, right? To be the petitioner, meaning they'll have to show their birth certificate, naturalization certificate, citizenship certificate, US passport, or copy of their green card. And then in addition to that, they also have to show that you have a bona fide marital relationship. So you're not going to be sending only your marriage certificate, but also other documentation that show the bona fides of your relationship, such as joint bank accounts, joint credit cards, if you have bought a car, if you have bought a house, if you rent a house, you have both of your names on the lease. Or, of course, as I said before, if you have recently gotten married and that person is outside the US, so you didn't have time or the opportunity to live together. And then other proof of that relationship, how genuine that relationship is. If you have children together, copies of the birth certificate of your children. And then in case, as I said, that you did not have the time to create that evidence to show that your relationship is genuine, you can show that you have been dating for some time. So communications with your spouse via email, via phone, via WhatsApp, via text message, and also pictures, right? With friends and family, and also letters from family and friends to corroborate to that other evidence that you have been together. And the intent of that marriage is not just to give that foreign national a green card. So once this Form I-130 is filed, if your petitioner is a US citizen, you can also file your adjustment of status together with your Form I-130. So the adjustment of status is filed through Form I-485. So this form, it's basically for you as the applicant, where you're going to show the government that you are eligible to change your status to become a resident of the US inside the country. So you're going to have to show that you don't have any criminal or immigration violation that would make you ineligible to become a resident, that you enter the country legally, that you have your birth certificate with you. If you have committed a crime, that crime doesn't make you ineligible. Or if you committed an immigration violation, that immigration violation doesn't make you ineligible. In case you are ineligible because you have committed a criminal offense, or if you have committed an immigration violation and then you qualify for that waiver, you also have the opportunity to file for that waiver together with your adjustment of status application. Again, only an attorney that is licensed in the US will be able to vet that process for you and screen you for your eligibility for a waiver. Along with your adjustment of status application, you can also request a work permit and a travel permit. The work permit will give you the right to work in the US. So if you are already working in the US under another type of visa, you have the option to keep that status, or you have the option to switch to that work permit to continue working in the US. Or if you enter the US with a visa that doesn't give you the right to work in the US, at that time, you're gonna have the option to start working legally in the US. You're gonna have the option to apply for a social security card. Also, if you don't have a driver's license, in a majority of the states, you're going to be eligible to also apply for your driver's license. That work permit will give you a lot of benefits until your green card is actually issued. Now, if you married a green card holder, that eligibility for you to apply for an adjustment of status will not be the same as if you were married to a U.S. citizen. And the reason for that is there is an annual visa quota, meaning the government can issue a certain number of visas per visa category and per country of birth. Whereas now there is a backlog, meaning there are not enough visas to be issued to spouses of green card holders at this point in time. Thus, once you file your Form I-130, until you are eligible to apply for your adjustment of status application, you are looking into a gap of about 2 years or so, okay? And now we'll explain that in more details in the next slides or so. So just in a very simple way, very simple terms, nowadays the whole green card process, if you are inside the US, takes anywhere between 12 and 18 months. I have seen cases where people got their green cards in 3 or 4 months, but this is not the average processing time. And then if you are married to a green card holder, that processing time will go up to 3 years to 4 years. Once you file that adjustment of status application, the petitioner is also responsible for filing a Form I-864, unless, of course, there are exemptions to that rule, but the large majority of petitioners will have to file that form with immigration. So that affidavit of support is nothing more than a contract that the petitioner will sign with the government, committing to provide enough income, enough support to that foreign national, so that foreign national will not become a financial burden to the US government. So the US petitioner is committing to provide income that is above the poverty guidelines threshold, depending on the size of the household. So in order to qualify and be able to not include a joint sponsor into the petition, the petitioner will have to show that they make a specific income per year, again, depending on the size of the household, or if the petitioner doesn't make enough, they can also show that they have enough assets to provide for that foreign national. If this is not the case, if the petitioner cannot meet this threshold, then the petitioner will have to find a joint sponsor. And that joint sponsor can be either a US citizen or a green card holder that is over the age of 18. That joint sponsor doesn't need to have any type of relationship, family relationship with the petitioner nor the foreign national. It can be anyone. That affidavit of support is valid until the foreign national becomes a US citizen, or until that foreign national has contributed to the Social Security Administration for about 10 years. So in case there is, and of course if the foreign national dies. However, if you divorce that foreign national before before one of those instances happen, that affidavit of support is still enforceable. And it's not only enforceable by the government, but also by the foreign national. So if the foreign national is facing a financial burden, and it's not just because the foreign national owns a bank or owns a credit card or has a bill with the with the hospital. This is not what that affidavit of support will cover. It will cover the basic necessities of that foreign national in the US. If by the time your green card is approved, if you have been married to that foreign national for less than 2 years, you're going to receive a green card that is also conditional, meaning your green card is valid for 2 years. The government will give you the opportunity to live with that foreign national for 2 years, and then by the end of your 2nd year anniversary as a green card holder, you're going to have to file another petition with immigration to request the removal of the conditions of your green card, stating that by the time that you have lived together during those 2 years or less than that, in case of divorce, of course, or in case of death of the US citizen or LPR holder, green card holder, or even if there is a domestic violence in the relationship, you're going to have to show that during this time you lived in a bona fide marital relationship. If by the time you go to your green card interview and your green card is approved, you have been married for more than 2 years, then your green card will be valid for 10 years. You don't have to go through this extra process of removing the conditions of your green card. So as I said, once you apply for your adjustment of status application, you have the option to request a work permit, which is the employment authorization document, and a parole, which is your right to travel outside the US. If you have a visa that is not an H or an L, that's what I recommend you doing. Go ahead and apply for those 2 documents, even though they will cost more. There is a government fee that you have to pay once you apply to receive those benefits. However, it will give you the freedom to work in the US while you wait for your green card adjudication, and they'll give you the option to travel abroad while your green card application is pending. Remember, if you travel outside the US, if you don't have a visa H or L, without that parole, your adjustment of status application will be considered abandoned. Again, after you file your adjustment of status application, you cannot travel outside the US if you don't have a visa H, L, or a parole. Otherwise, your green card application will be considered abandoned. In case you enter the US with an ESTA, with a tourist visa, or a student visa, make sure that you follow that rule outside all the time, and the money that you have invested into your green card will be lost. Right now, an employment authorization document is taking about 4 months to be issued, and a parole about 10 months. And those are the current costs for an EAD, $260, and for the parole, $630. If you, so as an immediate relative of a US citizen, and I'm not talking about spouses of green card holders, I'm just talking about spouses of US citizens. If you have a child that is not, of course, a child of this marriage, or if it's even a child of this marriage, but the child is not eligible to receive citizenship through the blood relationship with the parent, and then that child will also have to apply for a green card, you're gonna have to file separate applications for each individual. You cannot add dependents into your application. So the petitioner will have to file a petition for you as the spouse as well as for the child. And just remember, if this child is not the biological child of that US citizen, if it's a stepchild, that stepchild can only be qualified as a child of that US citizen if you as, the biological mother or father, you have married that US citizen before that child, your biological child, was under the age of 18, okay? So make sure that you understand that. Otherwise, that child, you have to go through a separate process to receive a green card. And I'll talk about Brazil later on, about common law marriage, because I know there are some Brazilians here, because in the past, immigration did not recognize common law marriage as similar to a civil marriage for immigration purposes. And about 2 years ago, that changed. So you see a lot of people that in the past would not have qualified for a green card as a stepchild, but now with this common law marriage recognition, this is now a possibility. So that rule that I just mentioned, that the petitioner will have to file separate form I-130 per immediate relative, applies to spouses, parents, and children under the age of 21. They will all have their own separate petitions and applications, and they cannot add any dependents on that petition. Again, being the spouse of a US citizen is different in the sense that if you have violated the terms and conditions of your visa, of your status, let's say you worked without authorization, or you let your I-94 expire and you remain in the US. Those two violations are automatically waived, meaning pardoned by the US government, meaning you don't have to request a waiver of inadmissibility if you have those two violations. Of course, if you have a criminal violation, that's a different scenario. Or if you have a different immigration violation, this is also a different scenario. I'm talking about working without authorization and having the I-94 expired. If you have one of those two violations, you can still apply for your adjustment of status inside the US. This is not the case for spouses of green card holders. As a spouse of a green card holder, you cannot have violated your status. Otherwise, you are not eligible to apply for an adjustment of status in the US. You should have, of course, been maintain your status by the time your adjustment of status is filed. So if you have an F1 status, you should make sure, you have to make sure that you are attending classes. If you are a tourist, that you have filed for an extension of your status. And this is specifically important nowadays because of the lack of visa availability for spouses of LPRs to receive their own green cards. So they have to remain in the US for a long time, maintaining their statuses in order to file an adjustment of status application in the future. If you enter the US without inspection, though, as I said, you enter the US through the border without talking to an immigration agent, you are not eligible to apply for an adjustment of status in the US, even if you are the spouse of a US citizen. You're gonna have to go through the consular process. And again, if you have spent more than a year illegally present in the US and then you leave the country, you're gonna have a ban of 10 years, meaning you need to apply for a waiver of that unlawful presence before you leave the US to attend your visa appointment to get your green card at a US consulate abroad. Same thing goes if you spend more than 6 months illegal but less than 1 year, and then you leave the country, you're gonna have a 3-year ban. And also, of course, if you have an expedited removal, meaning most of the times you were trying to enter the US and then the government deported you directly from the border and you received that expedited removal, you are not eligible to return to the US for 5 years. So as you go through the consular process, you need to apply for a waiver of that deportation. Of course, if you apply for your green card within those 5 years, within those 3 years, within those 10 years. And there is another violation that will make you ineligible for a green card for the rest of your life, which is lying and saying that you are a US citizen in writing or verbally to receive any type of benefit. So make sure that if you are in the United States, for example, and you are working illegally, and then someone asks you to fill out a form I-9, and then you have a fake US passport, or you have another fake US birth certificate, a social security, a driver's license, and then you check on that form that you are a US citizen, you might not be able to never receive a green card. And now, if you are outside the United States, or if you are not eligible to apply for an adjustment of status in the US, and you have to go through a consular process. So how the process looks like. First thing is the US petitioner, which is your US citizen spouse or green card holder, US citizen or green card holder spouse, will file a form I-130 with USCIS. So the form I-130 will be accompanied by the same type of documents that I mentioned before. And once this petition is approved, that petition is forwarded to the National Visa Center. And then at the National Visa Center, you're gonna have to provide more documentation before the government is able to schedule your visa appointment, your visa interview. Once you go through the adjustment of status application process, and I'm gonna also touch base on that again, you're gonna have to go through an in-person interview, both of you as a couple. Here in the US, this is now the standard under the Trump administration. As if you go through the consular process, of course, at a US consulate or embassy outside the US, the US citizen or LPR spouse is not required to attend the visa interview appointment. That will be just you as the applicant. So as far as the documentation that you have to present at US consulate or embassy abroad, the only difference will be police clearances that you have to provide for every country that you have lived since the age of 16, which is not the case here in the US, unless, of course, you have committed a crime and then you have to show the disposition of this crime. But if you are applying from outside the US, you're gonna have to provide those police clearances no matter what. You still have to go through a medical examination, just like you do here in the US. You're gonna have to submit your fingerprinting, just like as you do here in the US. Also, your petitioner will have to file an affidavit of support. And also you're gonna still have to present proof of the bona fides of your marriage. The difference mainly will be you're not gonna be able to receive a temporary work permit nor a parole. But I'll talk about the benefits later on if you go through the consular process when compared to the adjustment of status application. The adjustment of status application nowadays takes between 12 and 14 months. And again, as I said, it can be faster in some cases, but the consular processing, we are talking about 6 to 18 months after the form I-130 is approved. And this is base case scenarios when we are talking about spouses of green card holders, because it will all depend on availability of visas. So that processing time can be even longer. So I was talking about visa availability, right? I was talking non-stop about this for LPR spouses. Just listen to that if you are married to a green card holder. Because immediate relatives, they don't they don't fall under one of the preference categories. Therefore, there are visas available for them all year long. However, LPR spouses fall under the second family-based preference category, meaning the government has, by legislation, by law, a set limit of visas that it can be issued per year. So Andrew and Viviane, we're gonna have a Q&A session by the end of the presentation, so you can ask your question eventually, okay? So because of this limit on issuance of visas, depending on the type, as I said, depending on where the foreign national was born, because there is also a limit of visas that can be issued per country of birth. It's not country of nationality, it's country of birth. And depending on the volume of forms I-130s that the government receives per year, you're gonna have to wait in line longer than other people when compared to other people. But unless you are from China, Vietnam, El Salvador, Mexico, or India, there is now a waiting time of about 3 years from the time you file your form I-130 until a visa becomes available so you can get your actual green card. And how does that work? The US government fiscal year for immigration starts on October 1st of every year and then runs until September 30th of the next year. So during that year, the government can issue X number of visas per visa category, again, and per country of birth. For spouses of green card holders, as I said, you would fall under the F2A category. The Department of State is the agency that does that math every month. So every month, if you Google now, Visa Bulletin, US Department of State, you're gonna see that there is a monthly schedule. And then you can click on the last Visa Bulletin, for example, for August, because we receive the dates of the Visa Bulletin about 20 days before the month starts. And you're gonna see 2 tables, all right, per type of visa category. And you're gonna have one table that says final action date and the other table that says date for filing. If you are processing your green card from outside the US, forget about the table that says date for filing. If you are filing inside the US via adjustment of status, you're gonna have to look at what USCIS, which of the tables USCIS is using to accept adjustment of status applications. By the time your petitioner files your form I-130, you get your priority date. So you're gonna get a date on it. So that's your place in line. And every month, when you look at that table, if your date, right, if your date is before that cutoff date that will be written on the final action date table or the final action date table, you're gonna be able to either now get your green card issued or be able to file your adjustment of status application. Again, that does not apply to spouses of US citizens, only LPR spouses. So required documentation, basic documentation for both cases, your marriage certificate, copies of all US visas and passports that you have used to enter the US, as well as any other immigration related document issued by immigration, such as your I-20, your forms I-797, your DS-2019, and so forth. Proof that your spouse is a U.S. citizen or an LPR, as I said, birth certificate, naturalization certificate, citizenship certificate, or green card. Affidavit of support signed by your spouse and your joint sponsor if your spouse doesn't meet the minimum threshold, plus proof of income via showing the tax return. And then going through the medical examination, all of those documents will be required if you go through an adjustment of status application or consular process. In both types of application, you have to submit your fingerprints, you have to undergo a medical examination, and also if you are outside the US, submit your police clearance for all countries that you have lived since the age of 16. And here in the US, you just have to submit police certificates and also criminal dispositions if you have past criminal history. One of the most important things, one of the most important steps of a green card application, especially here in the US, is if you are interviewed by a USCIS officer, is the interview. Because during the interview, the officer will have the opportunity to look into your eyes and make sure that what you are saying, what you have presented, is the truth. So during the interview, of course, the officer will look into your eligibility to become a resident. As I said, you enter legally in the country, you were inspected, or you were paroled. You have documentation to show that you are a foreign-born national. You have documentation of that you are married to that person, that both of you terminated all your previous relationships, that you have good health, that the violations that you have, if you have any, would not require a waiver, or if a waiver is required, that that waiver was approved, that your US citizen or LPR spouse has documentation to prove that they have the required citizenship or green card status, and so forth. But they will also ask about your daily routine, right, as a couple. They will ask about where you have traveled together, if you have met each other's families, if you live together, if you don't live together, why you don't live together. Immigration is very conservative, even though we know that nowadays couples, some of them don't live together, they don't want to share their financials. The government is looking to get that proof from you. So the minimum I recommend is have a shared bank account, that you have transactions on it, that you have a shared credit card, that of course if you live together, if you own a place, if you have bought together, both of your names will be on the deed. Or if you rent a place, that you have your spouse listed as a tenant or even as an occupant. Again, photos of your trips together, but though this evidence is considered secondary, so any type of evidence that you can create, such as photos and letters from friends and family, those are considered secondary evidence. They will not be as powerful as the other evidence that I mentioned. If you have the opportunity to file your taxes together, this is what you should be doing. I have seen cases where couples, they separate the filings of their tax returns, but at least you have to list your marital status as married. And be honest. Lying as far as your previous relationship goes, and also your previous immigration and criminal violations, will not help you. The government can now investigate your social media activity. They can investigate your tax return filing history, your entries into the country. They can go back into your previous immigration files and see if you have lied or not in those applications. So being honest is the best thing that you can do, especially be honest with your immigration attorney before you file any paperwork with immigration. So your immigration attorney can guide you on what to do to mitigate any type of potential risks in the future. So what has changed now since Trump became president? What I have seen is that, one, everybody is being interviewed now here in the US. In the past, during the Biden administration, we've seen cases where the applications were being approved without an interview. There is an extra scrutiny and also further investigation into the bona fides of the marriage. Some of the cases that were clear-cut in the past, they are not the same now. And as I said before, don't think that the government will not find out that you have lied in the past or you have created a document that it's not real, that you have created fraudulent documents, because the government will find out. I'll give you an example. We have a case of a client that when she applied for a tourist visa all the way in the past, she lived with her boyfriend, and then she checked on the DS-160 form that she had a common law marriage, that she had a civil union. So when she applied for her green card now, she said that she was never married before, right? Because in her mind, it was, at the time, it was the right thing to do, and now, but she never filed a common law marriage document with the government in her home country. So she thought that was just because they were living together, and now she said, no, I was never married before, and I'm married to this US citizen. The government said during the interview, oh, but you said here back then that you were married. I need proof that you divorced that person before you married your current spouse who is a US citizen. So it all goes into whether she committed fraud or not, whether she wants to go back and get a divorce and then fix the paperwork. So this is just an example that the government is very smart, and the government can look into your past life. And I would say that nowadays it became more important to have someone representing you, because you never know what's gonna happen during this interview. If you're gonna be apprehended and put into jail, you never know what's going on, because now the government it's being extra, I guess, aggressive as far as getting everyone or picking everyone that doesn't have legal status and putting them into deportation. So be super careful. I recommend having an attorney, filing your application, even if it's the simplest of them. So now, tips for success. 1, make sure that you have documentation that proves that you are in a bona fide marital relationship. I'll give you another example. I have a couple that lived separately. They did not live together, and because of his company's settings and particular situation, he could not have anything together with his spouse, financially speaking. So when they went to the interview, the officer could not believe that they were actually married, even though she was super pregnant, just by the fact that they did not live together and they didn't have anything else to show that they mingled their financials. So it was like an uphill battle when we had to respond to the notice of intent to deny, but we got it. But again, this is something that it could have been avoided. Make sure that you don't miss any documents. I have seen cases being denied just because the foreign national submitted just the translation of their birth certificate instead of the actual birth certificate. So make sure that the application is complete. If you change address, if you separate, if you get a divorce, make sure that you communicate that to your attorney, because that can lead into, of course, that can lead into consequences that you cannot control. So make sure that your attorney is being 100% kept informed of all changes into your lives. If you are the spouse of a green card holder, make sure that you keep your legal status throughout the whole time. I would say that at least until your employment authorization document is issued. Again, to be more conservative, I would even say keep your status until your green card is issued. If you are married to a US citizen and you still have status, I recommend that you keep that status as much as you can. Of course, if you are already legal in the country but you qualify for the filing of your adjustment of status, be super careful now leaving your home, because the government is prioritizing deportation of illegal immigrants. Now I want to open the floor for any questions that you have. I know that Andrew and Viviane had a question. You can either speak or you can put the question here on the chat.
Yeah. Hey there, Bruna. Thank you so much for the presentation. We had a question around the timelines. I think you had mentioned for the applicants not in the US, there was some extended timelines for those different steps, and I missed writing them down. If you could just
Right.
repeat those.
So you need to wait for the approval of the Form I-130 before your case can be forwarded to the National Visa Center. So the I-130 itself is taking about 12 months to be approved. And then afterwards for the NVC, for the National Visa Center processing plus your interview, you are looking at about 6 months or so.
Okay. Got it. And then after that, so the I-130 is about 12 months. NVC plus interview is about 6 months.
Right.
And then for the steps after that, I think the next one is the visa approval and entry to US. How long? Yeah, what does that look like, and how long does that take again?
Sure. So yes, I forgot to mention that during the presentation, but once you pass your interview and your visa is issued, that visa will have a validity of about 6 months, 5 months and a few days, give it or take it. And then you have that time period to enter the US. So once you enter the US, that's when they will actually produce the green card, the actual card. And that takes 3 months. However, by the time she enters the country, the government will stamp her passport. And that stamp, it's her proof of her legal permanent residency for a year. So she can travel with this stamp, she can apply, she can get her social security card. If it doesn't arrive by mail, she can go to the social security office and apply for one, getting a driver's license and so forth, until her green card actually comes by mail.
Awesome. Okay, thank you so much.
No problem. And also, yes, so the remember that I was talking about having a conditional green card or the 10-year green card. As you go through the consular process, the date they'll look at is the date that the foreign national enters the US. It's not the date of the interview. So if you are super close to getting to your 2nd-year anniversary, it's best to wait until that passes to enter the country. So since it takes nowadays, let's say 18 months for the immigrant visa to be issued, right? Let's say, and you have another 6 months to enter the country, I would say it's best to see if you can extend your entry as much as you can. So you go ahead and get a 10-year green card instead of a 2-year green card, so you don't have to pass through this extra step to get the 10-year green card.
That is great to know. Thank you so much.
Can you show a combined income petitioner and recipient to show that the income is above the poverty threshold? You can, Don, just if that income from the foreign national is from a legal source, meaning that foreign national has the right to work in the US. So that person has a valid work visa. If someone is making money, let's say as a contractor, but doesn't have a work permit, you cannot use the foreign national's income. Did I answer your question? I guess so.
Bruna, hello. Thank you
I
very much for this meeting. So in this case where the foreigner doesn't have a work permit, it's let's say on a F1 visa or status, do you also recommend the couple to have a joint account? How does that work during the status, during the time that she's maintaining her status?
Yes, so basically, if your spouse is a US citizen, as I said, even if you were violating your F1 status, you are still eligible to receive your green card, right? You don't need a waiver for that. So in that case, I would say I don't see any problems with you having a joint bank account and putting that dirty money into the account, because you're gonna be, of course, coming forward and saying that you have violated the terms and conditions of your status. However, if this is not the case, if you are married to a green card holder, this is something that I will discuss offline with you.
Thank you very much.
Did I answer your question? Was that your question?
Yes, that was exactly my question. Thank you very much.
So if the recipient has an EAD and legally employed, yes. If you can show that this EAD can be extended, yes.
I have a question. Sorry. So basically, because like when you get like 2 years only, you have to file for get the 10 years. But once you get the 10 years, what is the next step for that? Like you go from there at any time to citizenship, or do you file for another green card?
So you have you are never obliged to become a US citizen, right? If you wanted to be a resident for the rest of your life, you can. To renew your 10-year green card, you don't have to go through a similar process that you went through the first time. The renewal of the green card is super simple. You basically, nowadays, right? I don't know how it's gonna be in the future, but nowadays it's super simple. You just fill out a form and you pay a fee, and that's it. Then you can renew your green card. But you have the option to apply for citizenship. If you have been married for your US citizen spouse for at least 3 years after the issuance of your green card, from the first green card, you can apply for your citizenship based on marriage. During this time, of course, during those 3 years, you have to show that you have been living in a bona fide marital relationship with your spouse, similar to the green card application requirements. So the 3 years is after green card issuance, is not prior to the issuance of the green card. If for any reason you divorce that US citizen before the 3 years, you have to wait 5 years until you are eligible to apply for citizenship. And then to apply for citizenship during those 3 or 5 years, you have to show that you have spent at least half of the time physically present in the US, that you have resided for at least the past 3 months in the state where you are applying for your citizenship, you have good moral character, you have not been outside for more than 6 months in one single trip, and of course you don't have any other violation that would make you ineligible to become a citizen, and pass the civics questions, civics and history.
Oh, thank you. And about after the interview, how long it takes for you to get the visa? Do you get it straight away an answer, or do you
It
have a
really
time?
depends. It depends. Nowadays, here in the US, I have seen a lot of officers taking their time to provide the final adjudication of the case. So it might take a few days, it might take months. It's very unpredictable nowadays. Whereas at the consulate, that same thing can happen, but usually after the interview right away, whether your case was approved or not. And then once your case is approved, I would say in about a week or so, you should receive your passport back with your visa.
Okay. Another question is because like I live in a different state, I'm overseas, and I have to go, for example, I live in Perth, I have to go to Sydney to do the interview. However, I need my passport to come back home and work life. So I heard from a friend they hold her passport, and I'm just afraid of they hold my passport and then I cannot come back to Perth. You know what I mean?
So you cannot fly using like an ID or I don't know, a work permit, any
Mm,
other type of document issued by Australia?
maybe I can check up. I went to Sydney recently, and nobody actually asked my passport, but I don't know. I just like, yeah, maybe I can check to see if is that a problem. If can I fly without a passport?
Because internally, at least here in the US, and even I'm talking about Brazil because I'm from Brazil, you don't need your passport to travel inside the
Oh,
country. You just
okay,
need a form of identification with photo. So if you have a document that was issued by the Australian government, that should do the trick as far as
okay.
you traveling inside Australia.
So if they hold, do they mail to you?
Yes, you can. I don't know specifically how Australia does, but you can pay for premium delivery for the passport to be delivered at your home, or you can also pick it up at a specific location that the government assigns.
Okay,
It
okay.
can be
So
like
just the
a
last
DHL
question.
location, courier location, or even their own location.
So okay. So is for sure they're gonna hold your passport or no? It's not every
Oh,
case.
for sure, because
Oh,
they need
for sure.
the actual visa sticker on it.
Oh, okay. Okay. Thank
Yeah,
you.
and it's about a week.
Okay. Yeah.
Anyone else?
We had one more question around if you, for example, if you have kids within that time period, let's say you begin the green card process outside of the United States, and you have kids within the like those 18 months to 2 years. What does that process look like?
So if the child, right, biological child of this couple,
Yeah,
right? So,
right.
and the child is born outside the US, right?
That's right. Yeah.
So that child, again, there are rules that will tell you whether the child is automatically a citizen if born to a US citizen parent, and then they have different rules for fathers and mothers. They'll look
Oh, wow.
into and whether the child was born in wedlock or not. So in your case, child born in wedlock of a US citizen father, they'll look into whether you have lived in the US for at least 5 years. And out of those 5 years, 2 were after you turned 14. So that child will be automatically a citizen, and then you have to apply for a consular report of birth abroad, as well as
Okay.
the child's US passport directly at the US consulate abroad.
Got it. Okay. Thank you.
Yeah, so it's all about, I mean, I'm talking about you specifically, right? But it depends on the day the child was born. So I'm talking about the future. So I'm looking at the past legislation.
Yeah.
And also whether the biological parent is a father or mother, and whether the child was born in wedlock or not.
Awesome. Okay. Thank you so much.
No problem. I guess that's it. Thanks everybody for joining. Leah, I don't know if you want to say anything. Thanks everybody.